Hello, everybody. Oh, here we go. This is fun.
All right. Mr. Moran, you're here because it looks like the state of Florida wants to come and get you. So this is just a hearing to see if you want a formal extradition hearing. You have the right to file a writ of habeas corpus saying that you are not the person that the state of Florida wants. You have the right to an attorney and to have an attorney represent you in that case. If you do that, then it triggers a formal extradition hearing, and it can take up to 120 days, of which time you don't get time served either here or there for any things that you have in either state. Is that what you want to do? Or
I don't know what that means. I'm just moving to quash or stay the execution of the warrant because it's invalid for violation of due process. I filed a not guilty plea in that case. I believe I sent your office all the filings I made in that case. I filed a motion. I'm a attorney licensed in Florida. I filed a notice of appearance in Florida. A filing of a notice of appearance in a criminal case by an attorney on behalf of the defendant requires that all filings or pleadings, anything in the case, be electronically served to the defendant's counsel at the email address. That never happened. I never got any of that. So the warrant is invalid under the U.S. Constitution and articles in the Florida Constitution, section 1.
That has nothing to do with Kansas. Those are things that you have to work out with the state of Florida. What you're here for today is to see if you want to file a writ of habeas corpus saying the state of Florida you're not the person that the state of Florida wants. If that's what you want to do, file your writ and have your formal extradition hearing. It's going to probably delay, well, I know it's going to delay your case in Florida if there is a case. Any issues you have with the state of Florida, Kansas has nothing to do with, and you know that. I'm not telling you anything new.
I don't know. I only took like one criminal law class, so I'm not sure. I just know that the warrant is invalid for violation of due process.
And you're talking about the Florida warrant?
Yes, but it's invalid for constitutional due process.
I mean, that's something you have to take up with the state of Florida. So you want to agree to have them come and get you so you can go and deal with that in Florida, or do you want a formal extradition hearing?
What happens at a formal extradition hearing?
It could take up to 120 days, where the state of Kansas gets together with the extradition departments and the government of the state of Florida. They decide if you're actually the Jason Winston Warren that they are wanting. They find that out, then they'll file those briefs in the extradition hearing. It'll delay that case 120 days. You'll remain in jail in Ellis County, Kansas, until that time. If
my position is that the warrant is invalid for violation of due process, and I request that the court just quash or stay execution of the warrant.
I'm not going to do that. I don't have the authority to do that. All right. So you have options. You can file the writ of habeas corpus saying you're not the person that the state of Florida wants. It doesn't appear that that's what you're making arguments to. It appears you're making arguments that the state of Florida's warrant is invalid.
That's correct.
Okay. That's not something that I can rule on today. All right. So either you can agree that the state of Florida has, I don't know, it's 14 days. I don't think I signed how many days they have to come and get you. If they don't come and get you within 14 days, then you'll be released.
It says until January 6th.
January 6th. So that's not even 14 days. If you agree to have them come and get you by January 6th, then they'll come and get you. You can go back to Florida and work out your issues that you have with their warrant being not constitutional there. Other than that, you'll have to file a writ of habeas corpus. What would you like to do, Mr. Morin?
I do believe this is his version of standing mute to the charges. Like most else, he doesn't understand what that means.
Okay, I'll tell you this. If you agree that the state of Florida can come and get you, you'll have to know that you have a right to an attorney in the extradition hearing. You have a right to have an attorney appointed, and you'll have to waive that right. There's paperwork there for that, for you to do that. If that's what you want to do, you can sign that paperwork. If not, you'll have to sign or you'll have to file your writ of habeas corpus and file for your attorney and have an extradition hearing. We'll see you again. I'll schedule to have you seen again if nothing comes over from the jail about that. We'll see you again. I'm going to say probably Monday to see if you've made that decision. We'll give you a few days to see what you want to do. I think that's all I have for you today.
This is in the District Court of Butler County, Kansas. Case entitled State of Kansas versus Larry Wayne Poole. It's case number 2023 CR 367. Larry Poole appears in the office of his attorney, Michael Studman, by Zoom. Amber Norris appears for the state of Kansas. This matter comes before the court at this time for sentencing. Court's docket notes indicate that the defendant appeared before this court on April the 12th of 2024. At that time, he pled guilty to count 1, felony theft, a level 9 non-person felony. A pre-sentence report was ordered, sentencing set for today. Court did allow him to appear at Mr. Studman's office for sentencing purposes. The court has received a pre-sentence investigation report compiled by Ryan Smith, pre-sentence investigator who is present on this meeting with us. I trust each attorney has received a copy of this report, and I'll ask the state's attorney first. Is there any objection to the criminal history which is stated therein?
No, Your Honor.
Is there any objection by the defense to the criminal history, Mr. Studman?
No, Your Honor, we believe it's accurate.
Court will adopt the criminal history as stated in the report and finds that the criminal history score applicable to today's sentencing is criminal history score E, and the court will proceed further accordingly. Does the state's attorney know of any legal reason why sentence should not be pronounced in this case at this time?
No, Your Honor.
I'll ask Mr. Studman, do you know of any legal reason why sentence should not be pronounced in this case at this time?
I believe the defendant is ready, Your Honor.
Very well. Mr. Poole, do you know of any legal reason or any other good reason why the court shouldn't proceed further with sentencing proceedings in your case?
No, sir.
Or proceed further then. Counsel, I'm not aware that there's been a motion for a departure sentence or any other sentencing related motion to take up. Does the state have any such motions to pursue?
No, Your Honor.
Does the defense, Mr. Studman?
No, Your Honor.
Are there any victims or members of a victim's family present who desire to address this court in relation to the Poole sentencing? I do note that there is an individual who may be a victim in the case on the meeting.
Yes, sir. I don't wish to speak right now.
Very well. Thank you. This time, the court will ask for recommendations from counsel regarding an appropriate sentence for Mr. Poole, beginning with Amber Norris on behalf of the state of Kansas.
Your Honor, state would be recommending regarding count 1, the theft, the mitigated 9 months in the Department of Corrections. Defendant would be able to earn up to 20% good time credit and would be subject to 12 months post-release. He has 1 day of jail time credit. And Your Honor, it appears that he does qualify for SB 123 treatment based on the new rules. So that would be up to 18 months with community corrections supervision. As the court assessed the costs and fees of the case to the defendant, court will need to assess SB 123 fees in total of $300 for assessments, etc. Ask the court to sign all standard and PSI recommended probation conditions. He has retained counsel, so the court does not need to address attorney's fees or the bid's application fee. And there is agreed restitution of $1,867.75 to the victim, who, as the court previously noted and heard from, is present. And Your Honor, I do believe he would be subject to the DNA database fee. His previous, it looks like, in Your Honor, he probably actually has already done it and submitted. One of his felonies was in Missouri, but the other one previous to that was in 2008 in Kansas. And I believe they changed that rule in like 2006 regarding the fee. So I don't think actually the court will have to assess that to the defendant at this time. I don't believe I have any further recommendations for the court.
Very well, Ms. Norris. Mr. Studman, your recommendations regarding an appropriate sentence?
Your Honor, I do believe probation with community corrections and the Senate Bill 123 mandatory treatment is appropriate. We would request that, Your Honor. My client has looks like 33 prior convictions, and a lot of those are related to issues that we would commonly refer to as pertaining to treatment and community-based programs regarding addiction. I think that could truly serve the community best interest in completing that. So we had asked for that, Your Honor. My client has been employed for almost 15 years with the same. He does work with siding and framing of homes and has done that and continues to do that.
How much money does he make doing that work?
How much are you currently receiving?
Probably about 300, 400 a month. Because I mean, it varies with the weather and the way I don't get paid till the jobs are done.
300 or 400 a month?
Well, yeah, because I don't get paid till jobs are done, and sometimes it's all kind of subcontracted. The boss he's been in and out of the hospital here lately, so I mean, it's been slow. He's been sick, so I mean, I just ain't been having to go to work. Not every day, but and sometimes, some weeks I make 800 a month. And sometimes, all depends on how much work we get done during the month. And so when a couple guys working, it's slow.
All right. Very well. Any further remarks, Mr. Stubman?
I think we agree with the state of Kansas on the disposition of this case, Your Honor. We had asked that he be placed on probation with those conditions that we described. Thank you.
Very well. At this time, the court will address the defendant, Larry Poole, individually, and I'll ask him if he has any statements that he wishes to make in mitigation of punishment or anything further that he would like to present to the court. Mr. Poole?
Well, nothing, it would be helpful on my side. I mean, I know the guy did steal the bike, he's in jail. I do know that in Oklahoma, Ryan Vineyard, but that's, but I take what I've done wrong. I stand up for what I've done, I take my punishment and I'm sorry
You
about it.
stand up for what you did wrong, Mr. Poole, and you're.
No, not the wrong, I'm saying it the wrong way. I'm admitting my wrongdoings, and taking my punishment.
Okay. I just was going to confront you about the statement you made in the pre-sentence investigation report. Your version of the offense is that you bought a bike. If you
Yes.
bought a bike, you wouldn't be sitting here today facing felony sentencing now, would you?
I guess not, but that's how I got it.
Anything further, Mr. Poole?
No, sir.
Before the court pronounces sentence in this case, the court wants to make several remarks. Mr. Poole, I don't really think that you're taking responsibility for your actions in the fullest extent. I will note you did enter a guilty plea. You did take some grudging responsibility for your actions this morning. But quite frankly, that statement you made in the pre-sentence report, I think just attempts to minimize your felony theft in this case. Further, I'm not pleased at all about that when you were assessed by seventh direction, apparently you refused to answer questions based on
No.
the report that I saw.
I answered everything that was asked of me.
What they refused is the UA, and you were not tested because of that. So it makes me wonder again, just how much other stuff that you're hiding and that will continue to hide as you go through a probationary process. With those remarks made, the court's prepared to announce its sentence at this time. Court hereby establishes count 1 as the base sentence in this case for the offense of theft, a severity level 9 non-person, non-drug felony in which the defendant has a criminal history score of E, thus placing him in grid box 9E. The court hereby sentences the defendant to the standard term of 10 months in the custody of the Secretary of Corrections of the state of Kansas. On this sentence, the defendant may earn up to 20% of good time credit and would be subject to 12 months of post-release supervision. The court has considered but declines to impose a fine in this particular case. The court rejects any suggestion here made by the plea bargain that this is a mitigated case. The court believes that Mr. Poole's actions or lack of certain acceptance of responsibility certainly suggests that a standard term is appropriate. The court does note that this is a mandatory case for Senate Bill 123 under current Kansas law, given the finding that he has a high probability of substance abuse disorder and that he has essentially high risk, high needs. And so the court will order mandatory Senate Bill 123, which is a substance abuse treatment program for up to 18 months, which the defendant is ordered to complete. Will also be placed on community correction supervision for a period of up to 18 months, with conditions being that he report to an officer as directed, observe all laws, not possess or consume alcohol or illegal drugs while on probation, at his supervising agency's request and at his own expense. He shall submit to random breath, blood, and urinalysis testing, perform any community service work pursuant to program requirements, gain and maintain employment throughout his probationary term, notify his supervising officer of any change in employment, residence, telephone number, or email address within 24 hours of any such change happening. He shall have no contact with the victim in this case. He shall abide by any curfew or travel restrictions imposed by his officer and pay all costs associated with this case in regular monthly payments. Mr. Poole, it appears to this court that you should be full-time employed. Whatever work you're doing that only earns $300 or $400 a month is not adequate. You've got to make right to the victim on restitution, which I will award to the victim in the amount of $1,867.75. That will be the priority payment in this case. This court will require the defendant to pay a minimum of $150 a month, starting with the calendar month of July of 2024 and every subsequent month until paid in full. Mr. Poole, if you can't make that kind of money at your current job, you need to get a different job. You appear to be very capable and skilled of working full-time, and the court expects you to do so. Court will be assessing a felony docket fee, felony probation fee, community corrections fee, $300 in Senate Bill 123 treatment costs. Court's understanding is, Mr. Studman, you retained counsel.
Yes, Your Honor.
Does appear that he's got a prior Kansas felony, so the $200 DNA fee will not be assessed here. Again, the restitution amount awarded will be the priority payment for all income that comes in from Mr. Poole regarding this case. And again, the court will expect those minimum of $150 a month to be paid on this case, starting with July of 2024. Court has considered jail time as a condition of probation in this case. Mr. Poole, it's actually quite common for this court to order 60 days in the county jail as a condition of probation in a felony theft case. Court's going to decline to do that here, not because of any great acceptance of responsibility on your part, but because I really want you to be focusing on victim restitution as a priority. And so I want you working as many hours as you possibly can, as soon as you can, so that you can start making those monthly payment obligations. Furthermore, I will note that this is a treatment-oriented case based on the Senate Bill 123 order in this case. So I want you in an approved substance abuse program and participating fully as soon as possible. Therefore, the court will grant the defendant 1 day of jail time credit, but will order him onto outright probation at this time with community corrections. At some point in the future, Mr. Poole, you may have the right to seek expungement of this offense. Certain statutory limitations do apply. If you have any questions about your right to someday seek expungement, you can address those questions to a lawyer and I'm sure get your questions answered. Under certain limited circumstances, a criminal defendant who's convicted may have the right to appeal their conviction to an appellate court having jurisdiction. And if they are unable to pay the cost of an appeal, the defendant may request the court to appoint a lawyer to represent them on appeal and that they be supplied with a transcript of trial court proceedings. Pursuant to KSA 223608C, you, the defendant, Mr. Poole, have 14 days after this judgment to file any notice of appeal with the clerk of the District Court of Butler County, Kansas. You do have the right to appeal this sentence if the court has ruled adversely to you at this hearing. I will remind you that there's prohibitions against a convicted felon possessing a firearm, and there are losses of certain civil rights, such as the right to vote, until your sentence is fully discharged. Please remember, Mr. Poole, that a focal point of this probation, besides payment of restitution that I've already mentioned, is the substance abuse treatment aspect of your probation. This needs to be taken very seriously. If you willingly non-comply with that requirement, you'll be back before this court and very well could be looking at an outright revocation and having you serve the rest of your sentence in prison. So you have an opportunity here to stay out of prison by doing what you're supposed to do: treatment, payment of restitution, reporting, and all the other requirements. I think you're fully capable of meeting all those requirements, and the court obviously will expect you to do it. All right, Ms. Norris, are you aware of anything further that we need to address regarding Larry Poole at this time?
I don't believe so, Your Honor.
All right, Mr. Studman, are you aware of any other orders to be made or any clarification that you need from the court?
I believe everything has been addressed. It's been very thorough. So,
All right. Mr. Poole, do you have any questions about the court's sentencing orders?
No,
All right. I have Marcy Taronis here, an ISO with Community Corrections. Ms. Taronis, what direction would you give Mr. Poole about getting started with your Community Corrections probation?
Your Honor, if I could please get a breakout room with Mr. Poole, I can get him all the information he needs.
All right. We're going to recess here in just a moment, Mr. Poole, but I need you to stay on the Zoom meeting so that you can meet with the ISO from Community Corrections, and she'll give you some further direction about what you need to do to get started on the program.
okay.
thank you.
All right. If there's nothing further then, at this time, the case of Larry Wayne Poole will be in recess, and we can stop recording and broadcasting at this time and leave the meeting open so that the ISO and Mr. Poole can confer.
Be safe, be well, sleep sweet, and much love.